Thank you. Thank you. Hey, everybody. Welcome to the Bold Patent Show. My name is JD Hoovener, and I'm with my co-host, Matt Colseth. Matt, good afternoon to you.
Hey, how's it going?
Going pretty well. I see behind you trees that don't have any leaves on them. What does that mean?
Winter is coming.
Winter is really coming. It's below freezing here. I just got back from a cruise. Did you know that? I did like a 5-day cruise.
I
to
did.
Bahamas.
How was it?
It was really good. It was super nice.
You got your festive shirt on.
I do. I kept it on. I'm still kind of in cruise mode. I like cruises. I couldn't help myself from thinking about, wow, what an amazing business cruises are. Like
Captive audience.
Oh my gosh. Yeah, it's incredible. I just watched this. I was one of the lemmings, to move all the passengers here, corral them here. How much organization, they have to do for just feeding the masses and then entertaining the humans. I just feel like
it's all offshore too, right? So like U.S. law doesn't apply, and so most of the hire are not U.S. citizens. It's a lot cheaper, and yeah,
it is. It is. We actually had a conversation with one of the wait staff, super nice guy. He's from the Philippines. 7 days a week, 10 hours a day. No break. And most of their contracts are 7 to 8 months. And he says, yeah, we get a break when we get sick. So I was like, oh my gosh. So I had to give him a tip, but they're generally smiling. It's incredible. So I was like, wow, I would not fly in the US. It's just interesting. But of course they're happy to do it. It's better compensation that they could get it back at home, perhaps. So anyway, it did a fabulous time, but I was definitely had a lot of things in perspective. And anyway, it was good to get away. So here we are. We're going to do a show today on intellectual property. And the topic specifically is, you know a thing about intellectual property, don't you, Matt?
Something new to me.
We're going to talk about what to do after. We spend a lot of time here on the show talking about searching, getting the patent. Recently, a lot about monetization, but this is actually after filing the application, where there's actually not much for us to do anymore. As the attorneys, we're kind of waiting on the patent office, the trademark office. So what should you do? And I'm going to kind of do my top 3, and hopefully you can kind of brainstorm some top 3 things to do. After you help someone file, what do you recommend for the client? And we'll get into that in just a little bit. I do also want to provide our link here and my disclaimer. Anybody that's showing up new, I'd love to get you to like our page and show up, here and ask some questions. We're attorneys, but we're not scary. We're not going to bite your head off. We're not going to be like, oh my gosh, that was a really dumb question. I mean, there's only, silly answers. And so that's what we're here to offer. And know that what we're talking about here, we're not giving away legal advice. Okay. This is just us as attorneys sharing information about the law, some examples, and we're going to do a really cool bold bite, we call it, where we do a segment of Shark Tank and give you our critique on how everything went, what we think they did wrong or well. And you can chime in with any live questions you have there. We will prioritize those live questions. And I've got a link, as I always do. I'll provide this for any action takers out there that today's the day and you want to move forward and take action. And I recommend if you do, get in touch with Bold because we do a heck of a job working with solo inventors, startups, and entrepreneurs. And so that weekly live link, click that and we'll know where you came from and we will waive our initial fee. So, and give you a copy of this book, Bold Ideas, The Inventor's Guide to Patents. It's a PDF. You can read through, get educated about the patent and the trademark process and get you moving forward.
Second edition.
Thank you very much. And that was released just last year. So, if you want a hard copy, I do this every now and again. Mention the key. Here we go. Matt, I'm gonna leave it to you. What's the fast phrase?
Jackpot.
You have to email me at jd@boldid.com with. How did you know I played?
You just got off the cruise, man. I know you
know I was at the casino. So email me right there. Mention jackpot to get a hard copy, signed copy of the brand new second edition Bold Ideas. So that's a one-time only deal. I guess these comments are going to be saved, but you still got to do that. If you actually take the time and email me, that'd be great.
Sure.
Okay. And next week, I'm excited. We're going to have one client on to share about his invention and where he's at now. He's gone to market, he's doing manufacturing, but he's kind of hitting some different snags. So he'll be able to share what he's up to. And we have some awful questions as well. So let's kick things off with what to do after your patent pending. So if you filed a patent application, you've got a design patent application. So that's where you've got a three-dimensional object, and you've submitted, for the most part, a lot of drawings, figures, line drawings, protecting that three-dimensional shape. And now you're waiting for the patent office to assign an examiner, do their own patent search, and then you're going to be doing responding to any rejections and working on getting that to allowance. So I'd say that the other type of application you may have filed is a provisional utility patent application. And that's for, I'll go to solo layout. Here we go. Big face. And then, so design app, utility. So on the provisional side, that's the less formal version of utility app. You have to have a full specification. You have to tell the government how to use your invention. And you have up to a year before the non-provisional is filed. So I want to spend a lot of time on the provisional. But there is another option. You may have filed the full formal NPA, the non-provisional application, and now you're waiting. So those are three different types of applications you probably have filed. So let's talk on the provisional first. Then we'll get into the DPA on the design and the NPA on the non-provisional. So if on a provisional filing, the best way to make use of your time is to make the invention, sell it, and then improve it. There it is. Those three things in a row, Matt. So making it, so getting a prototype, planning to do that. Okay, that's the first one. Under that, kind of the first bullet, there's some things to think about. Before you approach a third party, a manufacturer or a designer, or maybe someone you're going to collaborate with on how you're going to prototype the thing, you want to think about confidentiality. Even though you've already filed your application and you're now not at risk of someone else filing it before you do, there's still the risk of them, helping you improve it, right? We're going to fast forward to number 3 later. But as you talk with a manufacturer, it's inevitable they're going to find ways to build it, change the material type, different little modifications and tweaks as it gets built. And so because they're collaborating with you, you want to own and you want to keep anything that they discuss with you confidential. So make sure there's a contract between the both of you. And if you need help getting a hold of someone to help you draft an NDA, a contract, I can recommend one. I've got a really good network of business attorneys in most major cities around the US. So that's number one, is make the thing, go through the motions, prove it to yourself that it actually, can be constructed and built, and it's the way you thought it was, when oftentimes, the provisional application is still a theoretical. All right, so you've made it, now sell it. Go into the marketplace. You don't have to do this, but if you have the time and the wherewithal, go to market. The best, you're going to get the most candid, feedback after someone pays for your product. You're going to get an amazing amount of feedback, and what you have to be open and listen to it, receive the feedback, because that's how you're going to make iterations and improve your invention, which is step 3. Go through the motions, think about how you might make it even better. Whether it's the functionality or the way it looks. And, within number 3, that bullet of improving it, speak with your patent attorney about any major modifications. Even if it seems minor, you want to ask the question, hey, is this covered? Is this, if I change it to a different material type or have it attached to this type of system, did we talk about that in the spec? Is that something we can include in the non-provisional patent application? So in making those improvements is really the goal. And the best way to get to that number 3 is by making it and selling it. That's how you're going to get those improvements. So I won't take too much longer on the provisional. So on the design and then NPA side, it's kind of the same story. You just have less time because now the examiner is going to get assigned right away. And it could be a matter of months, sometimes longer, before you get an office action. And so you still want to progress into the market, begin, if you haven't already, make your product, and you want to also then sell it, go to market, and make improvements on it. So that's the beauty of having a provisional, is it gives you an additional year to do those 3 things before the examiner gets assigned and you're faced with a rejection and maybe locked in to a specific set of claims. So let me get out of the solo mode. Matt, I want to have you jump in if you don't mind for 5-10 minutes if you want on post filing of your trademark.
Yeah,
What happens?
it's certainly, yeah, it's not as complicated as the patent side, right? So we don't have any technical term like patent pending. But I often say your trademark pending, right? You have a pending trademark at the USPTO. While you can't enforce the mark in federal district court, or sue somebody in layman's terms, you do have rights in the mark, right? And those rights are pending. So after a client, files the trademark, or we file the trademark on behalf of the client, that's when the client is encouraged to continue to use, if they're not already using, the TM symbol. So you often see, I would say, like 3 different symbols commonly used from an intellectual property standpoint. You have like the copyright symbol, which doesn't apply to brands. It applies to like works of art or creations. And then you have the TM, and then you have the registered trademark symbol, which is the R inside of the circle. The TM merely means that you either have a pending trademark at the USPTO, or you believe that you have some sort of common law or unregistered rights in the brand that basically is not registered with the United States Patent and Trademark Office. What we're always gearing our clients to get is obviously a registered trademark symbol, so they can use the registered trademark symbol, and then obviously the whole host of rights that goes with that privilege. So, clients are encouraged to use the TM symbol, if not before they apply for the trademark, certainly after they apply for the trademark. And then to JD's point, we encourage them to go to market, assume basically based on the work that we did as your trademark firm, that if we told you you're going to get the trademark registration, that you're going to get the trademark registration. So go to market full force. There's no reason to wait until we hear back from the USPTO about whether or not they're going to approve your trademark. Because if it were today and I told you we're not going to hear back from the government for 10 months, you wouldn't want to just wait around, resting on your laurels until you go to market. You want to go to market now, I get it. So go to market after that application's submitted, because that's all the protection you really need. But yeah, go to market, start selling products, services. And obviously we keep you informed as the trademark works its way through the registration process. So pretty straightforward.
Totally. Yeah, I mean, I hear from inventors and business owners that they want to be more conservative, and they just, hey, you know what? I don't want to do anything until I get the patent granted, until it's in my hand.
Yep.
And I can see that, kind of the conservative approach. I just say that they're missing out on speed to market. Even if they are able to get that proprietary, unique set of claims. Other products can hit the market that are not infringing, and you may have missed a market opportunity. So
yeah, I love that. That's a great point, JD. And most of my clients, are not also patent clients, right? Most clients who have a patent could also benefit from trademark registration because they're probably bringing a product to market. Yep. So there's a lot of crossover in that direction. It's less the case that my clients as trademark clients have a patentable, product that they can bring to market. Right. But what they can bring to market, if they can't patent something, right, is they can be first to market. So no sense waiting around for somebody else to pick up your good idea and be first to market when you could do it yourself. So yeah, really good point, JD.
You bet. Yeah. We actually had a conversation with a client of ours. Obviously won't mention their name, but they actually didn't know that part of the patent side, I'm not sure if it's true for trademark side. Well, yeah, I think it is eventually, is an application gets published. It gets published before it gets granted. Yeah. And the client didn't know that. And, while we may have told them, we may not have told them that as much as we should have, right, in advance. And so they were shocked by that. They're one of this kind of on that side of, hey, I want to be totally confidential before this thing is patented, and then I feel ready to go to market. And it's a big deal. So when something gets published, it's going to be published anyway. If you're going to go to, you might as well share it and see if it is exactly as good as you think, if it sells as well as it does. If you wait until it's already granted on the patent side, you can be really limited. If you find out, oh my gosh, my product doesn't work as well as I thought it would, you're out of time. You can't file a continuation to modify the claim scope to match what you're going to be selling. So if you haven't sold, you're really risking and hoping that what you've invented is going to be marketable. So it is, certainly for the first time inventor, it's a huge risk to assume that your invention is going to be marketable.
Sure.
If you don't have experience. Obviously, for repeat inventor, a business that's been there before, maybe it's a less of a risk, but it's still like, why would you waste that time during pendency? So we encourage that action to move forward. Why not? And then one more quick note on that is there's the fear of, oh, someone's going to see my invention and rip it off, right? That's sort of the number one concern. And
but that's why you file a trademark, so you have file patents. You have a patent protection, right? So you can go enforce it if you need to.
Boom, you nailed it. The whole point of getting a patent is to enforce it, and it's a really good thing to see someone else infringe it. And even if it's unintentional, it means that the market wants it. There's a demand for the product, and if you follow the way that the law is set up to enforce you actually could have a business partner. You could have another business out there sending you royalties for every one of your products that are being sold for you. You didn't have to go do the manufacturing. You didn't have to go sell the product, and you have a way to make money right away. Yeah. So infringement can be a really beneficial thing. Don't be scared of it. Lean into it. Get out there and be bold. So that's my quick note on that. I'm sure.
Like that.
Yeah.
The timing is a bit different from a trademark perspective because your trademark application will be publicly available maybe 3 to 4 business days post application. So pretty quick, right? And so when you Google the business name or the trademark,
I didn't know that. 3 to 4 business days after. Wow.
So it's really fast, right? So it's more of an automated process, right? Okay. Once the application is in queue at the USPTO, it goes through like an initial review, and then it becomes like not necessarily published, because published is like a technical term of art.
Yep.
Meaning that third parties have the ability to oppose the trademark. So, but it becomes publicly visible, put it that way. And so when you go search your trademark name, like in Google, you're likely going to find your trademark application at the USPTO. Might get picked up by one of these third-party websites that tracks trademark applications, that sort of thing. But that's why clients should not be surprised after we submit a trademark application for them, that all these third parties start sending them emails or voicemails or whatever, because that information that we list in your application is publicly available, right? And so that's why we try to encourage clients to use a business email, business address, right? Get their personal information out of it, potentially, that sort of thing.
Very cool. Did you ever see companies or individuals, for that matter, sending opposition-like emails like, "Hey, you're applying for our mark"?
Yeah. So
opposition period.
Yeah, I get this question like once a week right now. So there's always a scam going on with trademark stuff. So the scam goes like this: you get an email, you're an applicant, maybe you're a client of ours, and you get an applicant, or you get an email, because we have to list your email in the application. You get an email from a Chinese law firm, and they say that somebody has filed your trademark in China, and you need to do something about it now.
Okay.
That something is pay them a lot of money to
do nothing. Yeah.
Right. That's one of the many scams that goes on. So we always tell clients like, hey, like after we apply to the USPTO, you're going to get junk mail, you're going to get junk email. If it doesn't come from me, or our firm, throw it away, ignore it, right? It's complete spam. So yeah, there's probably stuff like that on the patent side too, I imagine.
Yeah. You know what? And we need to step up our game a little bit and do a little bit more warning about that, because that's really smart. Okay. We're going to go to our bold bite right now. I don't see any live questions, and one live viewer though. So if you have that question, for whoever that is out there, hi mom, if that's you. So let me go to that right now. This is a company that, for me, I'm sure same for you, Matt. We just had our first conference, parent-teacher conference. Mm-hmm. So I know schooling is on the mind of a lot of folks. So this company is called Hopscotch. You may have heard of Hopscotch.
Oh, yeah.
You have? Okay, I hadn't before
I'm pretty sure I have.
Okay, kind of coding, gaming, and you can make some money as a kid as well. So here's the pitch. This was about a year ago on Shark Tank, and I'll share my screen here. Mark Cuban did invest $500,000 in this. We'll just watch the first 5 minutes or so.
Next Next up is a business hoping to inspire budding, tech-savvy entrepreneurs.
Hi, Sharks. My name is Samantha John. I'm here from Brooklyn, New York, seeking $400,000 for 4% equity in my company, Hopscotch. Back in the day when you were little Sharks, did you ever run a lemonade stand or mow your neighbor's lawn? Kids love running businesses because it's a way to make their own money and participate in the real world. But in today's digital economy, lemonade stands are a thing of the past. That's why I created Hopscotch. It's the best way for young entrepreneurs to build and run their first business on the internet, all from their mobile device. They use the kid-friendly programming language I invented to make incredible games that rival anything you see in the store. And that's not all, Shark. By selling those games to the hundreds of thousands of children in our community, they can turn their creations into real currency. And the best part, they're learning real coding skills that will be valuable tools in their future college classes and even careers. Through our fun educational app, parents will be blown away with what their kids can make. They'll learn concepts from game design to graphics, animation, and so much more. So Sharks, you've all talked to kids about how they are the entrepreneurs of the future. Here's your chance to put your money where your mouth is. Which one of you wants to hopscotch with me into the digital age?
Your last name is John?
My last name is John. I feel
and you
such
were
an affinity
from
with you.
Brooklyn?
Yeah, we might be family.
Might have to call my mommy.
So in front of you, you have an iPad, and I've chosen two of my favorite Hopscotch games in a demo version of Hopscotch for you to try.
You didn't pick the ones I did? That I posted on to Hopscotch with my daughters?
Oh, so the first game I want you to try is called Kaleidocosmos, and it's a drawing game where everything you draw will be repeated 8 times. So you make this really cool kaleidoscope drawing. And this game was made 5 years ago in Hopscotch. It's since received over 2.2 million plays.
Heck, it's a lot of fun to do, isn't it?
Yeah, can I see your drawing?
Well, I'm not sure I'm so proud of it, but there it is.
Oh, I love it. Oh, I like that. That's like a logo. Ooh, Kevin, I like that. Lori,
yes,
that
really,
is really
I call
pretty.
it man's inhumanity against man.
Damon, what you got? That is really cool. It kind of looks 3D.
Oh, Damon.
Yeah. The second game is a platformer game, and that was created more recently in Hopscotch. This game was made by a kid who has been on Hopscotch for over 4 years.
I got up to the first level.
Gotcha. Oh my God. Well, I'm not winning this game.
This is child's play, literally. I'm so ill with mine.
I actually want to show you guys a demo of how the coding in Hopscotch works so you can just get a sense of it. So this is the coding editor, and you're coding with these cool characters. I'm just going to walk you through making this game where the crocodile is going to go after the octopus and then it's going to eat it. And then you can just a little bit more code. You can start to see how this turns into a game. So now the crocodile has all these other people and it's getting bigger as it eats more.
It's pretty cute.
Thank you.
Samantha, tell us about you. How did you come up with this?
You know, when I was a kid, I never thought that coding was for me. I was like, computers, those are for boys. And it wasn't until my senior year of college, I took my first computer science class, and it was so empowering. It was so creative. And I was like, why didn't I know that programming was so fun and creative and interesting, and I could make things that people actually care about? So Hopscotch actually launched in 2012. And at that time, it was all free. And our first week, we got 20,000 downloads. So we got a lot of press.
You guys were on top of the world. You were dominating for kids' programming languages at the time.
Totally.
And there was no revenue at that time. You just
no revenue model. We were
Continue to
first-time
build.
entrepreneurs. We were like, grow.
Honestly, guys, like when it comes to kids in school, there's some other alternatives.
Yeah.
But Hopscotch is the go-to name. They crush it, right? And by the way, when I said I used it and posted an app, I meant it, right? I used Scratch, and then when my kids first got into it at school, we used Hopscotch
That's
and developed
awesome.
games.
It's intriguing. How do I make money?
So we have a currency that you can buy in Hopscotch from the App Store, and then you'll be able to use that currency inside another kid's game.
So that'll be the revenue. You'll keep the 2/3 of the revenue from the app you'll sell?
Yes. And then eventually we want to let kids share in the revenue as well. So we would eventually let kids cash out that they earn in their game.
What's the active user base?
Our active user base now is about 200,000 active users a month.
What was your peak?
Our peak was...
All right. Pretty cool program. I've never used it. Matt, was that the one you
No, it's totally different than what I was thinking, to be totally honest. So
okay.
Yeah, no, that's really neat though. Super cool, right?
Exactly.
Free child labor. They have an army of child labor programming for them, making their making their content. Amazing.
Yep. How about the trademark though? I'm used to. I'm obviously the Hopscotch game I'm familiar with, which is jumping around on different squares.
Yeah.
You like it as a play?
Yeah. No, it's great, right? I mean, like everybody knows, what Hopscotch is, in terms of like the old school game, right? And so when you say like I have an app called Hopscotch, that to me is, immediately suggestive of some sort of child game, right? Child content. So that's great. It's a highly suggestive trademark. It's catchy. It's memorable. Checks all the boxes. It looks like it is registered. At least one of them is registered at the USPTO right now. They have another pending application. But yeah, I mean, from my perspective, it's a great name. Yeah.
Excellent.
What about from a patent perspective?
Patent side, I wanted to mention something right away. I think this has got a lot of amazing creative angles here. On patent side, she did say something that is not true, and I want to make sure I correct it. You cannot patent a programming language, right? You've probably seen and heard a lot of coding, right? Source code, the actual typing of letters and words. That is a language. That's like the alphabet, okay? You cannot patent the alphabet or the words themselves. That is copyright law, right? So if you put together a new book, right, both ideas book, or have a new set of code, that is protected, can be protected under copyright law. That's like telling a story, right? You can tell a story in a million different ways. You can code different ways. So programming language itself is not patentable. But what she does have a patent on is software, a method of helping kids, in this case, code, where there's an actual functionality to using an animal that means something, that it actually provides that utility, and it allows someone to actually do coding at a young age and provide that unique string or set of inputs to have a unique and final output. So that is what's patentable here. I was super impressed with what she's put together. And I think the only potential downside, right, as a patent attorney, I worry about is that, yes, it does encourage the freedom of expression and sharing ideas and creations. Who owns the IP in the end? If a child does invent a new game, and I'm sure there's hundreds, maybe thousands of new games developed here, all of those games, the method and gameplay could be protected under patent law. And so if they're sharing that with the app and with the public, if more than a year goes by, they would not be able to capitalize on actually getting a patent for it. And while the games may not be as rigorous or sophisticated as some are, on the higher end with new PlayStation games or the PC games, it is important to consider that, right? If you're a parent of a child on the app and you think you put a lot of time and effort into producing an actual game with unique methods and gameplay, before you post it on an app like Hopscotch, I would encourage them to think through the process of, hey, is this really unique? Could I protect this with a patent first before posting it on a site like Hopscotch?
Do you think that Hopscotch has like a user agreement where like the parents of the children agree that it's basically a work for hire agreement, like they're independent?
I would love to look at that. Yeah, I bet. Let's see. I think what I bet it says is something along the lines of, as soon as you post it onto Hopscotch's site, it belongs to Hopscotch, right? Or you absolve Hopscotch, you give license for Hopscotch to use any and all parts of your game. What I would love for them to say is sort of have them stop at some point and encourage someone to protect it, or a warning, if you will. Hey, if you have come up with this on your own, you should, seek counsel, seek a representative to talk about intellectual property rights. But I don't know if it's truly a work for hire. That might be a bit aggressive, but
right? I mean, yeah, because like you think like there's just so many different angles there too, right? Because they're posting content, and like, what if they call the name that they post something that's already registered as a trademark, or what if that infringes somebody else's patent already, like what kind of review process does Hopscotch go through, right?
Right.
If they're going to get a piece of that action, right, they become, I would assume, jointly liable for any patent infringement at that point.
Yes.
So
Very, very curious. In fact, it might be good for some research, Hopscotch, and report back on an upcoming episode here.
Yeah, I would be curious to read their user agreement.
Yep, I love it.
Maybe I'll do that. That sounds like fun.
Matt, we're gonna wrap up. We got to the end of our show. I didn't get to the one question that came in over the week. We'll move that to next week.
Okay.
So let's do that. Any closing thoughts on your end, Matt?
No, super interesting. I'm gonna check out Hopscotch this evening, and maybe my oldest kid. My oldest kid loves Minecraft. She's loves it, right? And so anything that she can kind of build is like her thing. So this might be right up her alley.
Awesome. All
Take
right,
a look.
everybody. Well, for Matt and I, we are out. Thanks for watching the Bold Patent Show. We'll be back on Wednesday at 1:30 Pacific next week. We'll see you then.